Let's do.
Sure. All right, guys, so we'll start the hearing. This is the May 29th, 2025 hearing.
Logging to Zoom? Is he already logged into Zoom, do you know? Zoom, is it already logged into Zoom? You know, Chip?
I guess it doesn't look it up. I mean, if this thing is working, then isn't the Zoom working?
Well, you got your picture right there, of course.
Okay. Ryan, can you text me? I don't have anything.
You don't see the other people unless somebody signed on, right?
Okay, good. I just want to make sure we didn't have the lawyer.
I think we're okay.
Sorry. There you
I
go.
just heard the door open downstairs.
Oh, perfect time.
That's what I was looking for.
Cam, let's go. Why don't you have a seat at the table? Sure, right there.
295.
Oh, boy.
That's fine.
So we have just begun the hearing, the meeting here today. We have a representative from Freddie Flaherty here, town's attorney. We are the Board of Appeals for the town of Readfield. We're sitting here on a motion, possible motion for reconsideration to our last decision on May 1st. We need to approve the minutes, look at the minutes from the May 1st meeting and vote those up or down. And then we're gonna go on to what will probably be a quick reconsideration, because the one good lawyer in the room has indicated there's an exception on page 47 of the land use ordinance, table 2, under section article 7. So there's an exception that allows barns to be over the height limit.
Oh.
So this isn't properly before us. We shouldn't make a decision on this. This has to go before the planning board,
So it
I've
depends
understood.
on the classification of the use, whether it's just straight agriculture or whether it's intensive
they
agriculture.
think it's intensive.
So
The planning board, I spoke with Jack Comar and he understands that it has to, he's on the planning board. He
yeah,
understands it has to come before that.
so in that case, it would go before the planning board,
Yes.
they'd review, and then it would be eligible for approval
Right.
with this.
I don't think even with the planning board, height will be an issue because of this exception. They'll be looking at the planning board, will be looking at other things.
And that exception is in the LUO, right?
Yeah.
What did you say the number was?
It's
44, I think?
Table 2 on Article 7. It's footnote 4.
Was that referenced at all at the first hearing, at the first
We
variance? No.
thought about it, but no.
We didn't talk about that topic.
We missed it completely.
Yeah.
We missed it completely. So it's my understanding, we shouldn't have even, I mean, it shouldn't, if we had understood this, we wouldn't have had a variance hearing.
So it's my understanding that the applicant wasn't aware of it
Correct.
and that the town wasn't necessarily aware of it at the time. So the code enforcement officer at least, or whoever, told them that they needed to go for a variance appeal. Sorry.
There's the code
not
enforcement
trying
officer.
to throw,
Well, I also.
it's tucked away in a footnote.
Did they go to the planning board in the first place? I didn't think they had to.
Sure.
It has to go through me first.
That's what I thought, yeah.
As far as I was concerned, and I interpreted, okay, their use was, it wasn't a pure agricultural use. It was more for business, for, taking people in training. That being said, that was the case, and that was my interpretation. You have to come here first to get the variance for the extra 4 feet. There was also the question about, was this really a permanent structure? As was presented, that was discussed at your meeting. So there was various things that came up that would make the variance worthwhile. And we've had other applicants that have gotten through many meetings and then had to come back to the Board of Appeals. Most of your meetings are 1 or 2 meetings. We can go on for months. So my interpretation was to come to you all first and let you discuss it.
I'm sorry, I did not attend the first appeals meeting. Could you or somebody explain the issue around whether it's a permanent building or not, and what the discussion was around that?
We kind of landed on it, it didn't matter. The structure is a structure, doesn't matter if it's movable or not.
Is it a pole barn? Is it
It's an aluminum and canvas structure that's anchored with these, I'm assuming, big concrete blocks that have holes that aluminum goes into, which is upright. I think that's the way.
sort of a giant shelter logic
85,
structure?
no, 80.
And the height.
60.
The height was important because they want to be able to have so many horses that can go around the ring at the same time. And that 4 feet less impacts that by a significant amount.
Well, it also probably depends on what's available in the market in terms of
That,
the
that,
structure
the
and the
snow,
footprint. Square meter.
snow,
Yeah.
yeah.
Thank you.
So that's a brief recap. Have we looked at the,
The minutes were sent out to
Minutes?
everybody,
Yeah.
you commented
oh,
on
that's
them,
right, yeah.
but I
So
didn't-
has everybody had a chance to look at those as much as you do?
I thought I sent you clarification comments.
Yes.
Only that we discussed the issue ad nauseum, and I thought you made it sound like we just kind of brushed it off, but
Oh, I see, I see. I see.
he wants to look at that foolish, but I mean, it's just, you know.
Oh, yes, yes, and I think my response was, we don't include everything in the minutes. It's just, you know, it's just, since we have a recording especially, the minutes are kind of an antiquated item.
Really?
I mean, if you really want to know, you would go, what happened at the last hearing, you would go and view the recording. The minutes are just,
I did try to convey that, we discussed it quite a bit, I mean,
yeah,
but I didn't say ad nauseum.
right, right. So,
It seems to me that the first appeals meeting, perhaps now a little bit moot, given what we found in the LUO regarding the exception to the height.
it is. However, our first order of business on almost every meeting is to approve the minutes from the prior meeting. So we'll get that out of the way, and then we move on to the reconsideration. So
I move we accept the minutes that were submitted.
I second that motion. All in favor?
I'm going to abstain.
Okay. Ollie, you're in favor?
Yeah, yeah, I'm sorry, yeah.
So we have 5 members voting in the positive and 1 abstaining. Henry wasn't here at the last hearing. So those minutes are adopted as written. So now we move on to the reconsideration. I think we need to reconsider because we need to just void our old decision. Because, does that sound right?
So if the board wants to reconsider, the first order of business is to get a motion from someone who voted in favor and a second, and then we can discuss the merits of reconsideration, how the board might want to proceed, but it would have to go through the actual.
Yes,
vote to
yes,
reconsider
right, right. So we have to go through those procedural steps. Go ahead.
Just process-wise, do we need to reconsider now that we've approved the minutes? Or should we simply acknowledge and perhaps reconsider and void that decision and remand the whole thing to the planning board?
Well, it's not really a remanding. We would just probably be voiding it because it wasn't properly in front of us.
Okay.
That's a possibility. We can also just say, no, we're fine with what it is. We want to keep our decision. We could also rewrite a decision, a new decision. Those are all options to us during the reconsideration, but first we need to do the motion and get into a reconsideration if.
So you
that's
need
what
a
we're gonna
motion
do.
to either accept what we did or.
No, a motion to reconsider.
Oh.
So that, yeah, the way it works is, so you've got the final
So I
decision.
move that we reconsider
I'll second that.
the decision we made.
Okay,
Okay,
and seconded by Al.
and now we can sort of discuss.
All right, all in
Why?
favor?
Good question.
Sure, before we vote.
A reconsideration doesn't mean there's a denial.
No?
It's just that we're gonna go back and pause and discuss it.
So, so the way it works in reconsideration is you have the final decision from the prior meeting. You vote to reconsider, and once the reconsideration has passed, if the vote to reconsider passes, then it's treated as reopened. It's no longer a final decision. There's no prior approval that's there. But the board still is on the timeline to make a determination. If the board feels like the variance application wasn't properly in front of it, or it didn't necessarily have the authority to do this because there's potentially not a need to actually modify the provisions of the ordinance, then it could just say, we're gonna deny this for essentially like a lack of jurisdiction. Because there's nothing to modify here, because there's no denial from the planning board, which would be the approving authority or the entity that's responsible for determining whether or not this applies. If the planning board were to say this exception isn't available, then potentially the applicants could come back and request a variance and say, we need the exception now because we're subject to the 35-foot height limit. But where they haven't demonstrated that, there's not necessarily.
But aren't we being asked to be here by either the town manager or the town attorney for us to reconsider what we did? Isn't that why we're here?
Yeah, essentially,
In
yeah.
other words, so
Yeah.
we're being asked to reconsider it, right?
Mm,
Or
so
we're
we're
asking-
being asked to put it to a motion, if we
Okay.
wanna put the motion
Yeah.
out there, and then we
Okay.
can reconsider it or not.
But based on what Cam said, it seems to me that, this matter is really not under the jurisdiction of the zoning board of appeals. Because of the clause, the exceptional clause in the LUO, and really, if there were any jurisdiction, it would be the planning board. And so I don't think we need, it really isn't in our bailiwick. And I think it's fine to reconsider, but I think if we reconsider, I don't think the motion or the vote would be to deny the variance, but would simply be to acknowledge that the variance was appropriate coming forward to the ZBA in the first place. So there's nothing really to deny. I don't
Avoiding, are we not?
I'm talking now, I don't think we want to be on record as denying anything. I think we want to simply state that it's not our jurisdiction, and it makes more sense to have no opinion on this matter, because it's a
I'm fine
planning
with
board.
that.
It's a planning board.
Is it because of new information that was brought to light by the town attorney that it's not in our purview to review because it's a planning board issue?
Yeah.
What would that, I just said, the word void, what is that? We just void it, it's gone, we didn't make a decision one way or
We can
the
do what Henry said.
So the phrasing here, I think, is, not necessarily as important as the effect. So if it's denied for lack of jurisdiction, that doesn't mean that they can't come back and request it if it does become necessary. Or if it's voided due to lack of jurisdiction or something like to that effect, they'd have the same function, which would be to say that this variance approval is no longer there, and it's not necessarily preventing the applicants from coming back. It's just that it shouldn't have issued and is therefore being nullified or voided.
Excuse me, I think the language is important, that the word deny is a very strong denial of an appellant's request for variance. There's really nothing to deny. I think it's much more appropriate for us to say it's not within our jurisdiction. Therefore, our consideration on this matter is moot. If there's something to be considered under the land use ordinance, it should be within or sent to the planning board. But I think if we use the word deny, that puts us sort of in the headline world of Readfield ZBA denies height limits, and it just becomes inflammatory. It's putting ourselves in front of a red flag that we don't need.
How about something to the effect that additional information was brought forward by the town attorney referencing this thing, and that we heard what he had to say, and we were still fine with the decision that we made, although we realized that it should now, it's not for us to decide, it's for the planning board.
So when I send out an email, when we get an application for something and I send out an email going, hey, Board of Appeals members, here's the issue, we need to set up a hearing. I would normally this one wouldn't have gotten to that stage if I had seen this footnote. I'm
Because it
just
would have
saying.
just gone.
And we would never have a hearing.
Would have gone to the point.
Right.
Exactly.
But we've met in error, happens, so we kind of need to undo it. We have an application for a variance in front of us, and we wrote a decision on it. And if we reconsider it, we're reopening it, but we still have an application for a variance in front of us. So we would, I agree with Cam, the correct thing was we would deny for lack of jurisdiction. We just can't do it, and I agree, I don't think the words do matter that much, we're turning them down. And it's for lack of jurisdiction, it's not like we're weighing the merits of the case.
In this particular instance, Henry, one of the things that the neighbor came forward and brought information about all of the water that's coming down off of the hill.
I remember that, yeah.
And the water was coming down off of the hill because of the school yard with ball field that was done there, plus what they were doing. And then the addition of an additional structure that would take it, obviously there may be more impervious surface, or there may be more water. So I went over to take a look at what they were doing when it was raining, because, I wanted to see what they were talking about. And I talked with, when I worked for the watershed, I talked with Jay Lindsay about what he thought, because what we were trying to, the applicants that were here mentioned in many parts of their conversation that they wanted to do something to improve the situation for the neighbor. So I looked at it, there's a lot of water that's coming down. And not only is there a lot of water coming down, there's a lot of nutrients that are coming from the farm onto that property. So with these flash rainstorms, there's, and there's different things that can be done to make it so that not as much water leaves the property, or there's different things that can be done. But I don't know if that's more of a planning board thing. That's not what we don't get into.
The whole barn issue should not have been before us.
Okay.
So we shouldn't be talking about any of it.
Okay, but I'm trying to ask a question.
Yeah.
And the question I'm trying to ask, because I think if it was going to the planning board, they would have some of those questions.
Sure.
And there would be some of that stuff that would be resolved.
Yes.
And that's not something that we do at this point.
Not even
We
close.
don't, we're not into that.
We don't do it ever.
Right, okay, so I,
So that's kind of the form of what we're gonna do. We're gonna hopefully have a motion. We're gonna vote on whether we want to do reconsideration. Then we will reconsider, which is kind of what we've been doing. And then we'll hopefully come to a decision.
Yeah, make a motion to reconsider.
Okay. And any second?
I thought we already did that.
We already
Yeah,
did that,
Alright.
John did it, now
There's-
seconded
there's
it, but
a-
then,
We need to.
There's a motion on the
But
floor.
then let's ask
I thought I had some questions
All right, so are we ready to vote on that motion that's been seconded by Al?
that we're gonna reconsider.
Yeah.
Yes.
All right, all in favor, raise your hand. All right, it's unanimous, all six. So we are reconsidering. So that means that our old decision is, we have to write a new one now.
Yeah, it's opened.
Yes,
So
so it's open.
structurally, the way it usually works is you have the original decision, then you have a note under showing reconsideration, and then you have the determination based on reconsideration.
Based upon the information presented by the town attorney, that there's additional language in the code ordinances for the applicant to seek a higher height limit from the planning board, we now find that that's the place that they should go.
Right. So it shouldn't be for us. So we don't really have jurisdiction. But if the planning board makes a decision later, they could possibly appeal that to us, and we'll be ready for it at that point. Okay? So we have this decision that's been written. Apparently it'll stay like that, and we will make an addition at the end saying reconsideration. And we'll say something to the lines. It would just be a couple sentences I would write on. We met on May 29th. We reviewed the land use ordinance, Article 7. We feel like we don't have jurisdiction. And
Referring it to the applicant to refer it to the planning board.
so the application that is before us, a request for a variance, is denied due to lack of jurisdiction.
Mr. Chairman, I just have a couple housekeeping
Sure.
issues. I just want to I don't know if anyone can confirm whether or not a notice was actually sent out to the applicants
For this-
regarding this meeting?
Yes.
Okay, it was, okay. And then has a certificate for the variance been issued yet or not? Because we're still within
I don't think so. Recorded like at the registry?
issued or recorded, because if it's been issued, then if the board is going to rescind it, that should also just be voided, stated as voided in the,
It's my understanding that hasn't been done.
okay.
And the applicants knew that they had to go before the planning board for the rest of this whatever. So they apparently weren't rushing out to build this barn and get the variance.
You mean, apart from the height, they had to go to the planning board.
Yes.
For all the rest of the other.
Yes,
questions.
yes.
So then it's,
Because when I read them the 45-day appeal, they said, oh, we're not gonna be doing this anytime within 45 days.
And they were planning on going to the planning board after.
Yes, they knew that.
Chip recommended they come first to the ZBA.
They knew that when they talked to me. Any other housekeeping matters?
No, that's it.
Okay. So it'll be a new decision with the little added sentences at the bottom with the final effect being, hey, we don't have jurisdiction. And there'll
or it
be,
could also be that the land use ordinance provides a provision for the applicant to seek a higher building height at the planning board.
right,
I mean,
not,
it's already in.
right, not at all.
Right, so that's all we're doing is
Right.
confirming that there's
We
already
don't-
provision in place
Right.
for them to ask that of the appropriate.
Which is normally that email I send out, hey, guys, we have an application. I normally look at it, but the email is kind of like, hey, help me out. If I'm out in left field and there's a footnote I don't know about, let me know, and then we won't schedule the hearing. So for the future,
Yeah,
and I send those out.
a lot of cross references.
And that's what Peter was so good, when, because he would catch these.
Do you think he would? He's on the planning board now.
Peter would. Peter would.
Well, that's good.
Better
So,
catch it now.
You're doing a great job, I think.
Don't
Doing a great job.
know that.
No, doing a great job.
All right, so that's how the wording would work, I think, on the decision. Are we all okay with that addition to the decision?
I'm a word guy, I don't like deny, but I'll go.
Yeah. Yeah, I understand your reluctance, but
Well, can you just say it's not approvable? It's not our jurisdiction to be.
we have an
either applying-
application and we give a thumbs up or thumbs down.
Yeah.
So we approve or deny?
That's kind of, it's a binary choice.
Yes,
Yeah, we
it
want
is.
It's
It
approve
is.
or deny.
It is. And when I see these things ahead of time, we don't have to worry about denying for lack of jurisdiction. We just say, hey, guys,
It doesn't
we
come to us.
can't, it doesn't come.
It doesn't come to us.
Nice.
May I ask a procedural question or historical perhaps, yes? Has there been a case where variances come to the appeals board and it's because there's been an interpretation of the land use ordinance by planning board that would deny something from happening, but the applicant says, no, that's whatever, that's not the way we read it. Is that,
Sure,
has there been?
sure. The mirage
Yeah.
on the lake.
Yeah.
That certainly happened. And that's what we're here for. That's more what the Board of Appeals is for.
Well, the reason
That's
I,
how this,
brought this up is because what code enforcement officer said about, is this really agricultural? And I'm reading what agriculture means, and what land means, and I would say, just as agricultural as my neighbor who raises Galloway's sheep to sale and slaughter or whatever, it's not just a farm, it's a commercial enterprise, so. Whether you have horses running around in the wintertime, so that's purpose of buildings. Versus, raising animals for slaughter and stuff, I don't really, the way I read the agricultural thing, I just wanna, since that came up, along with the height thing, cause
do you think this isn't agricultural?
I think it is.
Oh, okay, then it clearly qualifies for the higher than
The way I
35
read
feet.
it.
Yeah, okay.
But
Then it
again,
clearly
That's not for
qualifies.
us.
if the planning,
Right.
that's where the code enforcement officer don't read this the way I read that. what they wanna do is not agriculture, it's commercial, or, you know what I mean, that's all I'm asking.
That's what you're saying?
But now.
No, no, no.
Agriculture is commercial.
No, no, I'm just asking because I heard what was said, and if we get this, it comes back because planning board says it's not agricultural, and my read says it is, so there should be no problem. And that's what I'm just asking.
But we're not-
Yeah,
procedurally.
it could,
We're not-
theoretically it could.
But we're not to decide that now.
No,
You
no,
know, we're
no.
not debating that issue now because it's not for us to
No, this would
debate.
be something down the
That'd
road.
be something down the
I know
road.
that, I know that.
All
And
right,
that's a planning board purview.
yes.
And it's not ours.
So the appropriate place for this conversation is at the planning board.
Right.
And thank you for the newfound information or clarification of the information.
Al, did we answer your question?
Yes, because
Anything-
after the last hearing, I wonder what we can actually approve, given the case law. Actually, I read through all the three cases that have been brought up. Interesting. All setback requirements, which I thought, you know, and that's a hard one. I read them and said, wow. Anyway, so, and they weren't that simple either, but anyways, so procedurally, there has been, and you say a lot, many, variances where the planning board interprets their own ordinances a certain way. Says, no, we don't agree with that, but the higher attorney comes in, and then we do that frequently,
Yeah, that's kind of why we're here.
not determining what's reasonable value to the property that,
Yeah, we don't have to worry about that. The court's done that.
they did it. Yeah, they sure did, so. Crazy decisions, if you ask me, but anyways, you're not asking me, so I'm not a judge, who cares?
You are more of a judge here on the Board of Appeals. You're more of a judge.
It's a quasi judicial board.
Yeah, you're more of a judge than a legislator.
Well, my thought in reading them though is that case law can be changed, but
Sure.
I mean, has there been anything had to do with height? Mostly setback, I would imagine. That's a huge issue. Wetlands, ocean, lakes, goes on and on, right, all the time has been, so.
I don't know. I don't know if there's been one exactly on time.
Al, if you reference the case law, the three cases you read relative to appeals that have come before this board? or-
They're
No,
quoted in the May 1st decision.
Yeah. It's the phrase reasonable return, which is in the statute, reasonable return. You know, but that's not for this board. I mean, it was those decisions, but like I said, I'm just trying to better understand where they were coming from for like, yeah, you were allowed to do this, but then things changed, so now you're not. So because someone changed their mind, and now you can't, even though you spent the money and bought the property, et cetera, so. Okay. Which is two of them anyways, yeah, so. But, I was just trying to understand all this a little better, so. So,
And
thank you.
It's not really fair, because we only get to do this when we have a hearing. I mean, we could call a public hearing, and we could just hash out reasonable return in public. What we can't do is get three of us on the phone together and talk. We have to have a public meeting, I understand, to debate these things. And we usually have an applicant that we're doing it live. And you know, we all have other day jobs, so. So it's tough. I think we're doing our best.
Do we need to have a motion and a decision and a vote?
Yeah, to end this part.
Okay. Oh, to end discussion.
To end the reconsideration? Are we okay with ending the debate now on reconsideration? Anything else anybody wants to add? So I'll move that we, in reconsidering our prior decision, that we add the paragraph that we previously discussed, which will essentially state that due to the footnote in Article 7, the Board of Appeals does not have jurisdiction on this matter, and therefore we deny the variance application due to lack of jurisdiction.
So,
Motion is seconded,
Al, second.
Yes. And all those in favor, raise your hand. It's unanimous, so that passes. We'll reconsider that, and I'll just send around a copy like I normally do. So that's kind of the why we were called here today. Cam, do you have any, has the town manager encouraged you to offer any advice on what we did on May 1st?
Not encouraged, but I've reviewed it, and I think this kind of gets to Al's question about reasonable return and the variance criteria generally. And there's a quote from a judge who won't be named, which might be, anathema or whatever, or just apocryphal, but he basically said, if you strictly read the variance criteria, no one will ever receive a variance.
Yeah.
And the reason for that is because it's a single statute, 30A 4353, I think, and it gives just this board the ability to essentially override the town meeting and say, okay, we think in this specific instance, because of these totally unique circumstances, you deserve an exception. And that's really the only time it's supposed to be used. It's not supposed to be used to allow something which isn't, allowed there for some reason or another within the judgment of the town. It's really supposed to be something that was an unforeseen consequence of a zoning ordinance. So, a town goes in and they adopt 30-foot setbacks within a zone, forgetting about this one property over here, which now only has like a 10 by 10 buildable lot or a buildable envelope. And that's the situation in which the Board of Appeals can then come in and say, okay, a 10 by 10 built envelope on this, however big lot is not workable. And therefore the property no longer can get a reasonable return. So we're going to enlarge the setback. It's those types of situations. And that's the tricky spot for not just this board, but for virtually every single Board of Appeals that I work with and staff. Nobody likes the variance criteria because it feels very restrictive, but it's very restrictive for a reason. And that's because it's really only supposed to address those unique, unforeseen circumstances, because if the town can come together and then legislate a solution, that's really the way it's supposed to work. Or if the town needs to legislate a solution or change something in its ordinance, it's supposed to be the town's decision. It's not necessarily supposed to be your decision, except in very unique circumstances.
Which makes us a judicial body, not a legislative body.
You are a judicial body. In the context of zoning amendments, you're sort of a little bit of both, but it's not a legislative decision-making process. It's primarily judicial. You're supposed to look at those specific criteria as, your standard of review, the applicant's burden of proof, and it's up to them to show that they've suffered that undue harm or would suffer that undue harm if the ordinance as written is applied to them. So it's not the advice any board wants to hear when you pull authority away from them, but it's unfortunately the way, as Al mentioned, the case law is structured, and the way the ordinance has been, or the statute has been interpreted. So that's my spiel on it. I'm happy to answer questions. I personally haven't seen a height related finding, but the principles of those cases
I
nonetheless
don't know
govern.
if it matters with reasonable return height, whatever, it's like we can't approve anything. And given that, the one that the parent that was the oldest, I think, in Cary is like, people buy subdivision, 2-acre lot, get approval from the town to subdivide that to 1-acre lots. And they got approval to build on the They built on one, they build on the other, probably sell it. Okay, hey, we're gonna go ahead and the town changes the ordinance. These new kinds of wetlands, so setback issues. And the judge said, I mean, the thing got really, reading is really complicated, but the judge said, yeah, you were allowed to build on that. But now you're not. But the land has value because you can stick it back onto the 1 acre like it originally was, and therefore you have land that's value. I mean, I'm going like, okay, so I just don't understand these decisions. The one that was, the one that you mentioned, with the boat and.
The the
That,
potential
that
recreational
became
use.
complicated because the original owner didn't do anything within a year. And that made the null and void. He went bankrupt, the new owner said, oh, I can build because the prior owner had variance, which didn't carry through, there was no record of it. And the new code enforcement officer or whatever, they said, no, you can't build anymore. But so there's legal complications to this stuff, but I still, is there any, well, do you know of any reasonable return, a decision, reasonable return on any land for anything? I didn't see any, it could be, right?
So there's sort of conflicting precedent that says that it doesn't mean the land has no value, but it means that it has no practical use. So I don't know how you necessarily balance those two or work out the difference there, but generally, if land can be used in the way that it's intended to be used, and there's just some specific thing that you want to do that can't be accomplished without a variance, that doesn't necessarily mean it doesn't have a reasonable return. And that's like the boat case, and I'm not sure if that's the one that deals with the recreational, like the available recreational use of the property.
Yeah, I mean, it was.
And that's, if you follow that to its, extremes, you say, I've got this 4 acre parcel that I can't use, but you could make walking trails on it, so now it has a reasonable return. And it's a case by case situation, but it's supposed to be kind of a it when you see it thing, where it's supposed to be, like I said, the way I generally describe it is it's supposed to be something that was an unintended result of legislation adopted by the town, like an accident, and that's what the board is here to correct without the need to go back to the town to get it modified. But
the whole issue of intended use and no practical value or value is a rabbit hole. I mean, it's very, very deep and gets to appraisal and highest and best use and all of that stuff. And intended use, whose intention? Is it the landowner, is it the town, or is it the neighbor, or is it God, or who's intending what?
And again,
It's fraud.
Yeah, it's a very tricky statute, and I think it's tricky, and the reason the legislature hasn't gone in and made it broader is for exactly this reason, which is that it's supposed to be very restrictive and not supposed to be something that just gets used so that somebody can do something without having to ask the town to allow them to do it.
Because of variance, essentially, if granted, would be undoing the legislative decisions of the town.
Correct. Yeah. You are granting an exception to the legislation that runs with the land, and it runs with the land too, so it would be permanent. It's not just just for you exception. It's this property is now for this specific building or whatever is now no longer subject to the height limits, or anyone who owns this property in the future can ignore those setbacks.
When does the concept of grandfather come into play, as Al's example, the prior owner, and that sort of thing, and when does the town, through legislation, new order, changes to the ordinance, for instance, change the highest and best use value of the land because they made a legislative decision at a town meeting to change the ordinance? Suddenly, is there a taking, or is there a grandfathering of a prior value that could have been recognized and used? How does that sequencing manage over the course of time?
So grandfathering is usually just limited to specific uses of properties and specific structures on properties. So if you've got a boatyard, and all of a sudden there's a change in, or, say it's like let's just say it's a store, just say you have a store on your property, and all of a sudden it's done purely residential, you can't have a store there anymore. If that store continues in operation, it's a grandfathered use, it's allowed to remain, because if the town said you can't operate your store anymore, then that would be effectively a taking, or a regulatory taking, and then the town would have to pay
But
some
the hypothetical
compensation.
use of the boatyard owner would not be grandfathered because it was merely hypothetical, it was kind of agreement inside.
Exactly. He had not built the structure yet, and he had not actually commenced the use. He just owned the property at the time that use no longer became permitted, so therefore he lost the right to engage in it.
So I have a question. So there's a tiny little piece of property on our land that I tried to buy when we bought our property, and there was a neat old cabin on it. And an old lady owned it, and she just let it fall apart. She never did anything with it. So she declared it derelict to try and reduce her taxes, which really didn't do any good because it's lakefront. So she's gotta die soon. So somebody's gonna inherit this property, and they're gonna wanna do something with this. It's only like, the lot can't even be 100 feet deep.
Uh-huh.
So
So if the lot's non-conforming and the structure's non-conforming, so we're getting so into the weeds here. First of all, I'm surprised you put, a wish for somebody to die.
no, I didn't wish for her to
But,
die, but I'm just saying.
she said she's got it.
But she was old when I asked her to buy the property, and she wouldn't sell it.
Uh-huh.
And so then she declared it. I don't want her to die because it'll actually be worse for me,
Fair
because her relatives are probably gonna wanna do something with the property, whereas she just wants to hang on to it. So no, I don't want her to die.
So without getting too deep into hypotheticals, basically the way that works is there's a non-conforming structure or a non-conforming lot, and then if the structure is completely dilapidated or has been
And she
destroyed.
declared it derelict, and she hasn't been paying taxes on it for like 5
Yeah,
years.
So then, well, first of all, the town might own it, and second of all, there comes a time when you've allowed the structure to remain in basically a state of diminished or destroyed value past the time period provided by the ordinance. And so you no longer are allowed to reconstruct it in place. You would essentially have
The old
an
50% rule
unbuildable
that
lot.
if you can,
Exactly, yeah.
okay,
Diminution in
so it doesn't
value
apply.
at the date of destruction of the property. So if it's been officially declared as derelict, abandoned, or destroyed, or something like that, or condemned, that would be, I think, probably a strong argument in favor of that is the date on which it was reduced in value by a certain amount, and therefore you would have lost the ability to,
So they could just camp on it, basically.
without passing judgment on the actual situation.
Well, I understand that. I was
That would
just
be-
curious.
That would be the
I
approach.
just wondered, because with all
But
this
yes.
talk of variances, and I thought, I can just picture these people are gonna come in.
Yeah, so
And
now
build a
they,
big house on this little piece of land.
Just a couple more things. I'm still a little confused. Now, the case that Will brought up, case law is 1995. Is there anything more recent? Are those three still the predominant cases to determine reasonable return? Let's just clarify that. The other thing is, has there been any decisions by a board of appeals in any municipality that said, yeah, that, this will affect a reasonable return? Apparently there's not, is there? Is there?
so there are many cases out there on variance appeals and variance applications. I'm not aware of any that have significantly modified the interpretation of
Reasonable.
the reasonable return or any of the other elements. As to how boards of appeals act generally, some are strict, some are not strict. And ultimately it comes down to the potential exposure to the town. If somebody were to challenge the appeal or challenge the variance application, the approval, or challenge the denial, then the town finds itself defending a decision that it might not have needed to defend.
Sounds like we're progressing into workshop mode here.
We're totally there.
Yeah.
We're done.
I was
we're
gonna
done
say, we're debating theory,
We're-
which is not what we're here.
We're done with the reconsideration, and if you wanna leave, you can, we're just chatting.
Let's just-
But,
I appreciate your time. It just helps.
And my
me
wife.
try to get it.
Sure.
Oh, a minute, sure. Will usually goes over.
Do you need a motion to
Make sure I
adjourn?
got all the legal schmeagle right.
I move to adjourn.
I second
All in favor
of adjourning.
of adjourning? All right, it's unanimous.
Thank
Thanks,
you for coming, and
Yeah, thank you.
Rob, it's nice to have a find something there to help it along
Get it out of
properly. Well, help it along properly.
Yeah.
And the drainage
How
and
do I-
all of that issue will be at the planning board.
Yeah,
You know, John,
I'm normally,
yeah,
like I
I
said,
wrote-
you know,
I
these
wrote my
guys,
bicycle
it's
design.
not a major issue.
Well, thanks, Will.
Thank you. Thanks for coming out.
Yeah,